كلية الفقه الحنفي تقدم
Assalamu alaikum wa rahmatullahi wa barakatuh. My dear brothers and sisters, Allah bless you all. I hope you've had a wonderful first semester, and we're about to start the second semester of the second year, and there's some new chapters ahead of us. Inshallah, we're going to discuss in this introduction, we're going to discuss what we're going to cover inshallah during the next few sessions, and then we're going to move on to a next chapter. This chapter that we're going to cover right now is still related to the whole concept of the judiciary in Islam. It's a related aspect, but it can be done separately as well. So that's why it's being brought here. It's called Kitabul Qisma, the chapter on division and distribution of assets, essentially, right? Now, alhamdulillah, may Allah subhanahu wa ta'ala bless Prince Ghazi and the Wise University for setting up this Hanafi Fiqh BA course. I think it's probably the only one in the world, mashallah. So may Allah subhanahu wa ta'ala accept it and benefit us all through this, and benefit a lot of other people through our students as well, inshallah. So as you know, that these lectures are being provided by the White Thread Institute from our teachers and our fellows, and pray for us as well. So what we're going to be looking at is Kitab al-Qisma. Kitab al-Qisma, to provide a basic overview, we're going to discuss what exactly it is, what are the conditions for it, what's the definition for it, what's the need for it rather. And then after that, we're going to go through the procedure for it. It's going to discuss, can you charge somebody to divide? For example, if I have a joint property with my brothers and we can't agree on how to distribute it, that's probably when you're going to need somebody, right? When there's a difference of opinion, or when you can't agree to do it in a particular way, right? That's usually what's going to happen. So you need a professional, official divider, a distributor. So who pays for that? For example, in that case, if he's going to charge something, who pays for that? That discussion is relevant. Then usually it's going to be among inheritors or partners, and then now they want to separate, they want to use something independently, their portion. Then it's going to discuss how different things are divided, whether that be money, whether that be animals, pearls, jewelry, and then there's a whole discussion about what is divisible and what is not divisible. So all of that discussion, and then is who has to be there in the while it's being divided. If one of the parties are not there, will it be valid or not? So all that is what we're going to inshallah discuss. So we say Bismillah to this, Ya Fattah, Ya Fattah, Ya Fattah. So Bismillah wa salatu wa salamu ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'een. Amma ba'd, we ask Allah for making this easy for us. So firstly, let's just discuss division overall in Islamic jurisprudence and what it's all about. So division is, Kitab al-Qisma essentially refers to a chapter on the division and distribution of property in Islamic jurisprudence. It deals specifically with how joint ownership is dissolved and how shared property is then divided between co-owners or inheritors in many cases. So the word qisma itself, from qasama, which means to divide, to separate, translates to division or apportionment, right? Now in this context, Kitabul Qisma addresses various issues related to dividing assets, such as the rules governing how to divide it fairly between individuals, whether they're co-owners of a shared asset or heirs to an estate. Methods of resolving disputes regarding division of assets. And then, as I said before, the distinction between divisible and indivisible property, and how compensation or adjustments can be made with when a physical division isn't feasible. Like in some real estate, it might be difficult to divide it in a way that they both get exactly equal square meterage, right? Or square yards. Or if they do, then some portion of the buildings or the land has more buildings on it, and it would be silly to divide it completely half and half. So then how do you compensate one another and adjust that? Then we have the discussion of under what conditions can an individual demand a division or opt for a compensation? Like, is there a choice? And then, of course, the roles of judges or mediators in overseeing and ensuring any kind of fairness, right, in a division, right, especially if it goes to court. So it's a very important aspect of the Islamic civil law and judicial law that ensures equity and fairness in property distribution. Of course, the principles are all rooted in the Quran and Sunnah and the broader framework of Islamic ethics. Right? There's a lot of that understanding. So the goal of the qisma is actually to provide a practical solution to disputes while adhering to legal principles. So having said that, again, we're going to be covering this from Kitab al-Quduri with the commentary by Imam Maydani. And if you want to follow along, it's essentially page 195 of volume 5 of the Baghdad edition. I think the Baghdad edition has 5 or 6 volumes. This is the 5th volume, and he has some nice, annotations in it. So if you want to follow, you can get that copy. There may be also PDFs available of this, and I'm on page 195. So you can follow along there, or you can just listen. It's up to you. Right. So he says, لا تخفى مناسبتها للقضاء لأنها بالقضاء أكثر من الرضاء. There's no doubt of its association with qada because it comes after the chapter on Adab al-Qadi, and there's no doubt that there's a relationship there because in more cases than not, it's going to be demanded through the judicial process rather than people just coming to an agreement. Right? I mean, in many cases, people just decide to do it themselves and kind of agree and they settle, right? But in many cases, it has to go to court because people aren't willing to settle, or they're greedy, or they're selfish, or yeah, so there could be multiple reasons. I've already explained all of this. وهي لغة اسم للاقتسام وشرعا جمع نصيب شائع في مكان مخصوص. Literally speaking, qisma refers to division, right? Dividing something. And in a technical sense, in a Sharia sense, it refers to, interestingly, the way they say it, is that let's just say that me and yourself, we're partners in a car. Now, there's no way that in a car we are partners of exactly this half and that half. It's going to be proportionate, spread ownership, right? Common ownership in the whole car. You owe, because we paid equal amounts of money maybe, you owe 50%, you own 50% of the car, I own 50% of the car. I can't say that this gear stick is mine and not yours, so you can't use that. Or this steering wheel is yours and it's not mine. Or this seat is yours and this seat is not. It doesn't work that way, right? Because a car is not a divisible object. Or what is a divisible object and what is not? Usually they say divisible objects are those things which after being divided can still maintain its major usufruct, major usage, major benefit. If you split a car in half, it's going to become redundant. I mean, currently they don't have splittable cars. They might have self-driving cars, but they don't have divisible cars. Maybe in the future they'll, and I think there was something from what I recall where it was a one-person car, but you can then add it onto another one-person car and drive together if you want to. Okay, well that's not then a normal car as we see it. So we're talking about normal cars as we see them, right? Where splitting them up is not going to. So we would say that that one car, even splitting that car that only holds one passenger that can be a component of another car, even that, if you split that up, it become useless, right? Except for scrap metal or something else, right? You'd have to salvage it. So that's what it means, that divisible objects are those things that retain their major usufruct, right? Not just any usufruct, but major usufruct after splitting and division. Otherwise, they're not divisible, right? So a car is one of those things. So regardless of that, anyway, we're not getting to that yet, but that's just to keep in mind. Regardless of that, when I own something together with you, for example, then even if that's 10 kilograms of rice, 2 kilograms of dates, some nice ajwa dates, you own 1 kilogram, I own, because you know, maybe I told you to buy it for me from Umrah, so you bought it all together. Hey, give me 2 kilos. You came back. Okay, now half of this is mine, half of this is yours. So you're going to have to split it, right? Now, some things are obviously easier to split. And I mean, dates, if you split them in half, okay, by kilos, by weights, they're all pretty much similar anyway, right? Unless somebody's causing a problem. No, I want these particular grains and not those ones, you know. Then you have to either settle or go to the judge and let them do it, right? Anyway, so until then, until the division, I own 50%. That means 50% of every date, of every particle there. And you do too. I can't say this is mine and that's yours unless we decide to split it. But until we don't, we own 50% as a commonly owned share. That is what they call in Arabic, it's sha'i'. It is essentially spread in everything. So every molecule of that is 50-50 between us. So then a division in another sense is then to gather my 50% or 40% or whatever it is, gather it together and separate it from your share. That could mean separate it in a way that, you know, half of this becomes yours, half of that becomes mine by the grains or by splitting the land in half or whatever, so that I no longer do we co-own every single molecule or every single particle or every single grain or piece, if you understand what it means now. Now I have my share and you have your share and we don't co-own it anymore, right? It may still be next to one another, but it's not co-owned anymore. That's essentially a jam'u nasibin sha'i'in. It is to consolidate together the spread ownership, right? The spread portions within the whole item, to consolidate that fi makanin makhsus, in a specific place or in a specific way, right? What causes that to happen? Well, it's going to be the need of the partners, obviously. If the partners demand it, then it has to be done, right? It doesn't have to be demanded by everybody. Let's just say that I own something with you and only I am demanding it. It still will have to be split. You can't say, no, I don't want to split it, because you don't have that right. Then we'll have to go and get it split. So any partner that asks for a split, because everybody has a right in Islam to their own self, you know, ownership of something. They don't have to be in partnership forever. That's something very important to understand. So if I demand it, I can get it. We'll have to split it. You can't refuse to split it. Okay? Okay. وَشَرْطُهَا عَدَمُ فَوْتِ الْمَنْفَعَةِ بِالْقِسْمَةِ. However, what is very important is not to split it in a way that its major benefit or usufruct is lost. Then what's the point? Then what do you do then? If I don't want to be your partner anymore, you don't want to be my partner anymore, what do we do then? Well, buy somebody out or sell it. Sell it to somebody else, divide the money, share the money. Or I sell my section to you and you sell your section to me. So, or I sell my section to somebody else with your agreement or without your agreement, but then you'll have some preemption rights. And then he becomes or she becomes your partner instead of me. So there are other ways to deal with this. But if I want to maintain it, I want my share, unless it's a case of where it's going to lose, then it's just being silly, right? Okay, al-qismatu mubadalatun aw ifrazun. Usually a division is either going to be done through some kind of exchange, or it's going to be done by separation. So that depends on the product. Dates, we can do it by ifraz, which means just by separating a kilo out. It's quite simple, right? Whereas in other things that are more complicated, let's just say that there were 5 inheritors and several different buildings, real estate. You can't literally, it would be wrong and it would be silly and it would be non-productive to split up every single one of those properties into 5 sections. Say, okay, you take that one room in that one, and you take the hallway in that one, and you take the bedroom in that one. That's just not gonna, silly. So what you would do in that case is they would have a settlement that, okay, I'll take this building and I'll take that building and you take that building and you take that particular asset, and you'd value it and see that, okay, if this house is bigger than that one, then I pay you, right? I pay you for the excess of your share that would have been in here, because we're going to value the whole property. It might be $1 million or £1 million, and we're all due 200,000 equivalent, but this house is worth 250,000, then I owe 50,000 to somebody else if, for example, they received a house of 150,000, for example, right? So that's what you call mubadala, where there's going to be some kind of exchange, some kind of settlement of an exchange, that your part for my part, because sometimes it's difficult to do it just completely by splitting up the asset. So hopefully that's very clear. To explain that a bit further, I mean, this concept of exchange in there is usually going to come about because, as I said, if we start off with the fact that we both owned the car or the house, the car is a different story because that's very difficult to split up, right? But let's just say the house. So obviously I own 50% of every particle of the house, and so do you. So now if we decide that we're actually going to split the house, it's a splittable house, maybe upstairs and downstairs, right? So you're going to take the top, I'm going to take the bottom. You're going to say, oh, the top actually, you know, costs less or is valued less because you have the garden and the yard with it. Okay, then obviously whatever my ownership is in the top part of the house and your ownership at the bottom, we're going to exchange that part. So I'm going to relinquish my rights to whatever I own in every particle, 50% of every particle of the top part of the house. You're going to relinquish your right and exchange that for my right, right? So my right in the 50% of your house is being exchanged for 50% of your right in my house. So now you own the full top, I own the full bottom. Now if there's going to be a difference of opinion, difference of value, then obviously I'll have to compensate you, you'll have to compensate me. It could be that the house at the top has more rooms because maybe we've got 3 rooms at the bottom, 3 rooms on the first floor, which you're going to take, and then you've got 1 or 2 rooms in the attic. That means you got more. But then we might say, oh, I've got the yard with it, and you won't have access to the yard maybe. So unless we got shared access to the yard, then you still got more rooms. So if I'm going to take the full yard, you're going to take more rooms, then maybe we can evaluate together. You know, you have to do it in a friendly way to make it work, unless genuinely somebody's losing a lot, then, you know, you don't want to be unfair in that regard. So you can see there's always an exchange aspect in there, right? So فهو يأخذه عوضا عما بقي من حقه في نصيب صاحبه فكان مبادلة من وجه وإفرازا من وجه. So in that kind of a situation, it's going to be an exchange in a sense, and then it's going to be consolidation of all of my ownership in one aspect. You can, I mean, that's quite clear now. Now, when it comes to fungible items, right, like rice or dates or wheat, those items that, you know, are easily replaceable, you can find them like for like and so on, right? They're not kind of unique in a sense that, you know, each part of it is separate to the other, different to the other. No, they're usually, one grain of rice is very similar to another grain of rice of the same sack because they usually come from one field and so on. Or they've been mixed up in a way that doesn't allow that kind of distinction. So, وَالْإِفْرَازُ وَالظَّاهِرُ فِي الْمَكِيلَةِ. So in anything that is usually sold by weight, sold by volumetric measure, like 1 liter of this, 1 gallon of milk, والموزونات, and likewise anything that is weighed, sold by weight, then usually those are just going to be easy to separate out. You don't need to do mubadala. You can just say, get out of the gallon, just give me half a gallon of milk. It's simple. I don't have to then make some major, although there is an exchange, but it's mostly just a separation. Okay, pour half of it in here and I'll take that, right? There doesn't have to be any big negotiations in that. Likewise, a bag of rice, 2 kilos of dates, for example. لعدم التفاوت, because there's not really much disparity in the asset itself. حتى كان لأحدهما أن يأخذ نصيبه حال غيبة صاحبه, such that in this particular scenario, in these particular types of items, a person is actually allowed, one of the parties are actually allowed to take out his portion without the other person being present. You can't do that in a house, for example, because that's not really a fungible item. You can only do that in these weighed and volumetrically measured fungible items, because it's quite simple. That, okay, you left me a kilo of dates. They were all similar. You can't say, oh, you took the good ones or the bad ones. If that was the case, that there were two separate types of kilos, then that wouldn't be allowed. Then you'd have to take half of this and half of that, right? You just have to split them up that way. Unless somebody was genuinely selfish and, there were a slight different amounts in terms of different sizes. There were some smaller ajwa, some slightly larger ajwa, and the person literally chose all of the big ones and took those. And there you could see that that was premeditated unfairness, right? But otherwise, usually in anything fungible like that doesn't have much disparity, you can even split it yourself and leave the other part for your partner, right? Because it's going to be quite simple. Right, now, in other things where there's going to be a lot of disparity between it, it's not like the same item. Like a house, for example, how do you split half a house? Because somebody might get one of these rooms and somebody might get this passage, somebody might get this entrance. How are you going to do it, right? It's got one entrance on the side, one entrance on the front. Who takes the front entrance? Who takes the side entrance? Or are we going to both use the front entrance, but then it's going to be split up from inside, and the entrance hole is going to be, a common area? How do you split it up? Because, usually houses aren't made in a way to split them up like that, right? In a perfectly splittable way, divisible way. So that's why he's saying that in those kind of cases, you need a give and take. You need some kind of a settlement of exchange, right? So in that case, you're not allowed, one partner is not allowed to just split it up on his own and say, okay, I'm going to take this share, you take that share, right? I guess they could do that if they're a really good guy and they know what the other person wants, because they've had that discussion before, and your partner wants that particular portion, so you're becoming selfish, like, okay, you take that. But again, you can't do that unless the other person agrees. So it just means that when the person agrees later, it's going to be really implemented then, right? Okay, so except that in that kind of a case, if what we see with a lot of people is that they just refuse to split. They just refuse to split because the whole place does take a hit, like a house being split. It does sometimes take a hit, but sometimes it's usufruct. The person can live at the top, live at the bottom, one person can live at the bottom, or they can split it up in a way that works, right? So he does say, إِلَّا إِنَّهُ إِذَا كَانَ مِنْ جِنْسٍ وَاحِدٍ أَجْبَرُ الْقَاضِي عَلَى الْقِسْمَ عِنْدَ طَلَبِ أَحَدِهِمْ. Except that when things are of the same type and same genus, same category, same type of item, then the judge can definitely compel the other partners to divide it if one of the partners demands it, because it's easy to separate it, because the objectives of all of them are the same. I mean, dates can be split up, and so can rice and other things. And likewise, when you have to do like a house or something, ultimately it's going to have to be done. The Qadi can actually force it. However, if it's something like animals are not considered fungible products classically. Now, maybe we could issue a fatwa to say, because they're produced in like factories, almost like the chickens. They're produced like in factories, that they all grow exactly in the same way and so on, right? It's kind of crazy, right? And very unhealthy in that sense as well. But so if, for example, the joint items, the jointly owned items are a cow and a sheep and 3 buffaloes and 2 horses and 5 deers, that you can't split each one of them up because you'd be killing them, right? Yes, if they'd all been slaughtered and you're just going to separate the meat, then that's easy, because you could kind of split it up. However, if they're alive, you can't. So the judge can't force a split there. What he can force instead is, because it's going to be difficult to decide on, who gets what. because there's just so much difference in terms of the objective of each of those animals. Horses are for riding, oxen are for tilling the ground, buffaloes could be for milk, cows could be for milk, chicken could be for eating. So it's going to be much more difficult in that case. What they would have to do in that case, they still have to split, but what they would have to do is they would have to settle in the sense that they would say, okay, you take 5 chickens and I'll take, you know, this smaller animal, and you take the larger animal and I'll take 2 of these animals. So you'd have to just settle somehow, because it's going to have to be split eventually, but you can't force them to cut them in half essentially. Then judicially speaking, according to the judiciary as an appointment or as a necessary service by the Islamic judiciary, that's what he did. He says, وَيَنْبَغِي لِلْإِمَامِ أَنْ يَنْصِبَ قَاسِمًا يَرْزُقَهُ مِنْ بَيْتِ الْمَالِ لِيَقْسِمْ بَيْنَ النَّاسِ بِغَيْرِ أُجْرَةٍ وَيُقْسِمْ بَيْنَ النَّاسِ بِغَيْرِ أُجْرَةٍ. So he starts that discussion. So he says it is recommended for the imam, the qadi, the judge, the counselor, the mayor, whoever's in charge of the town, right? Whoever's in charge of the process and the civil service and so on, right? That's what we would say today probably, right? It's recommended for them to appoint a divider, right? Appoint somebody that will undertake the division, a distribution company, a division company, right? A service provider. And he should be paid. He should be paid from the Baytul Mal. He should be paid from the council, from the national treasury, so that he can do it for people whenever they need it without having to charge them. So Imam Quduri is going by the view that this should be a state service, a free state service that's provided, because he's saying that a division is from it's one of the services of the judiciary, because that what's it got to do with judiciary? Because that is one, when you have things divided, it can stop a lot of arguments, a lot of division, a lot of disputes. So get it separated, get it divided, and then stop having to take on cases about it. فَأَشْبَهَ رِزْقَ الْقَاضِي. So in that sense, he's justifying it to say that just like we're allowed to pay a stipend for the qadi, a wage for the qadi, we should be able to pay a wage for a service provider of a judicial service, right? فَإِنْ لَمْ يَفْعَلْ. If they don't do it, because it's a recommendation, it's not obligatory, then نَصَبَ قَاسِمًا يَقْسِمُ بِالْأُجْرَةِ. Then okay, if he doesn't want to do it they don't want to appoint somebody and pay them for free, then they should appoint somebody who then will have a charge. So the people will pay. Whoever needs the division done, they will pay, and they won't get it for free. Then Imam Maidan usually discusses all the reasons for why a mas'ala is the way it is. So he says, because لأن النفع لهم. Why should they pay? Well, they're getting a benefit. They are deriving benefit from this. وهي ليس بقضاء حقيقة, and we can't force the judge because it's not really a judgment. It's not strictly a judgment. So we can't say that it's definitely, the judge has to provide it. So also, it's permissible for this person who's appointed for division, he is allowed to take ujrat for it. He is allowed to take a pay for it, because it's not there's a physical aspect involved in there, and it's not purely that judge appointment. Now this is probably harking back to an earlier opinion that imama, to lead prayer, to lead and to teach Quran and to do a judge, you're not really allowed to take a wage for that, because these are all important aspects of the deen, and how can you take that for something that's an obedience as such? However, later they allowed it. وَإِن لَمْ يَجُزْ عَلَى الْقَضَاءِ كَمَا فِي الدُّرِّ عَنْ أَخِي زَادَ. He says, even though it's not allowed to take a wage, or you can say charge for giving a judgment, because actually the charging for giving a judgment is separate to leading the prayer and so on, because there's no conflict of interest in leading the prayer. Whereas when it comes to whoever gives me more, then I'm gonna, decide more favorably for them or something. So that's why it's not allowed to do that. Yes, they get a stipend from the government, right, from the hukuma. But here, because they're saying that you can charge the people you're doing it for directly, a judge can't do that. So they're just justifying that a judge can't do that. But this is not strictly this is not strictly judiciary. It's related to it. So it's okay for them to charge. قال في الهداية والأفضل أن يرزقه من بيت المال لأنه أرفق بالناس وأبعد عن التهمة. The Hidayah says that it's superior, it's better, more virtuous, more advisable to appoint him and pay him from the national treasury, because that's just more compassionate approach for more compassion with the people, more compassionate measure with the people, and also it's further away from any kind of conflict of interest and any kind of suspicion that might come about with that. Right, now if you do appoint somebody, how does he have to look? What does it not how he has to look, but who does he have to be? What are the conditions? So ويجب أن يكون المنصوب للقسمة عدلا. Number one, he better be an upright, trustworthy individual, reliable individual, as we discussed before in the shahadat and so on, because this is obviously related to qada, and in everything in qada you have to have reliability and uprightness. مأمونا, he should be somebody who is trusted as well, so that you can rely on what he says, that people will take him, and he's not seen as somebody who's unfair usually. عالما بالقسمة, knows how to divide things. Obviously, if he doesn't know how to divide things and does it, in an incorrect way, then he won't be able to do it properly. People won't be happy, right? ولا يجبر القاضي الناس على قاسم واحد. However, there shouldn't just be one person set up for this in town. Why? Because he might start charging too much, because he has a monopoly. So they should have a few, so there's a competition. Subhanallah, our Islamic buyu system allows for competition and a free market in a sense, right? Not ultimate capitalism as we have it today, but definitely allows for a free market in that sense. Because he says, لا يجرهم على أن يستأجروه, he should not force them to just hire this one individual. لأنه لا جبر على العقود, because number one, you can't in any kind of contract you can't really obligate somebody to undertake a contract like that. ولأنه لو تعين لتحكم بزيادة على أجر مثله, and if he was then stipulated as only one individual, then he would have a monopoly. He would be obstinate, he would be stubborn, he would go over the retail price of this, the commonly understood price of this. Okay, now he says that, look, you don't have to go to one of these people. If وَلَوْ إِصْطَلَحُوا, meaning if within them the inheritors or the partners decided to agree and settle, is completely permissible. The only time it's not permissible is if there is a minor who's a shareholder, who's a partner. Minors, they have a special ruling that they can't make the best judgment for themselves, so they may be swindled, they may be cheated out and just hoodwinked in a sense. So if there's a minor involved as one of the partners and shareholders, then they can't do it within them, they have to get a third party to do it. You have to, and for that it can't just be any third party, right? It has to be the judge. There has to be the judge, because nobody else has that kind of authority over them, right? ولا يترك القاضي القسام يشتركون كي لا يتواضعون على مغالاة الأجر فيحصل الإضرار بالناس. Another thing is to avoid them, the multiple dividers in town, or dividing agents in town. The judge should not lead them to start collaborating with one another just so that they don't fix a price, right? In order to, if they fix a market value price, that should be fine. But if they fix a price to make it more expensive. Hey, you know, like different gas stations or petrol stations have done before, companies have done, hey, we're not going to drop below this price, right? Just so they can, people are desperate, people need it, right? And they have no choice anyway, and you're going to have to go. It's very difficult to boycott these kind of things. So it's gonna cause harm to people, so they don't allow that. And then they're saying that, okay, how do the shareholders, the partners, how do they pay? Who pays out of the partners? Okay, you're gonna have to pay, but who pays? And how do they pay? وَأُجْرَةُ الْقِسْمَةِ عَلَى عَدَدِ الرُّؤُوسِ عِنْدَ أَبِي حَنِيفَةَ. According to Imam Abu Hanifa, he says, just go by the heads. Just go by the number of individuals involved. So if there's 5 people that he has to split for, okay, the price, the service fee, has to be split into 5. لأن الأجر مقابل بالتمييز وأنه لا يتفاوت. Because ultimately what you're paying for is his division. His division is not going to change much in that sense. And it's difficult maybe to... So sometimes it's very difficult to determine a price for something just by how many, just by the type of division, because sometimes it might be a small thing that you're trying to divide, but it may be more intricate and more complicated to divide, right? And something is a large thing and it might be easy to divide, but other times larger things will be complicated and smaller things will be easy. So that's why just go by the actual number of parts and heads that are going to receive it, and that'll be easiest. Essentially what Imam Abu Hanifa is saying is just go by the heads, and he can then have a value for that, and that is what he will charge. Sahibain, on the other hand, they say ala qadr al-ansiba. No, it's going to be on how many parts he has to make. So if there's sometimes it's going to end up being the same, right? Because it's straightforward, 5 portions I have to make. So the portion price is going to be same as the per head price, because each person is going to take a portion. However, sometimes you've got multiple properties and he has to split each of those properties into 5 portions or lands or whatever, because nobody wants to exchange, or the case, right? Then in that case, he's going to make 5 portions here, 5 portions there, 5 portions there. That means that he goes by portion. Ultimately, I think that while this is going to be the case, but I think ultimately whether you do it by portion or whether you do it by heads of partners, the time it takes to do it is probably going to be the same, and that's why these dividing agents will eventually it's going to be the same price, I think, because if it takes them an hour to do this and an hour to do it, you know, both ways, then they're going to just charge for an hour of their work and then just split them to 5 heads or 5 5 portions or 20 portions. That's what I think it's going to be. In some cases there may be actually a difference, right, a real difference, but Allah subhanahu wa ta'ala knows best. So because it says لأنه مؤنة الملك, because that's part of the burden that comes with the ownership of that now it has to be spread, so it should be distributed accordingly. Nasafi, Mahbubi, etc., they have gone with Imam Abu Hanifa's view. So to round up the whole section, we looked at the definition of it, we looked at what it's about, how it's related to the judiciary, and we discussed a very important difference between some things are divided literally by just very simple separation, and some things you need a kind of a settlement because there's an aspect of exchange in there, because there's a portion which is unique to the other portion, is different to the other portion. The person may want a part of this and a part of that, or they may exchange and settle and say, okay, you take that share and I'll take that, even though this is smaller, but it's closer to the street, or whatever the other reasons are. So it could be those kind of differences. And then we discussed that the Imam should set somebody up and appoint somebody for this, and then the difference of he can either pay from the judiciary, make it a state free service, or otherwise make them pay, and how they pay. That was the last discussion that we have. So inshallah we'll see you for the next session. Inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.